As you are already aware by now of the huge shock that greeted all of us about Mazi Nnamdi Kanu. Firstly, it was about his failing health conditions. And then we all woke up to a sudden breaking news that Mazi Nnamdi Kanu's court case is now on 26th of September, which is on Friday. Many people are optimistic about his release, which is good, because in life, you must hope against all odds. Talking about hope and faith, for this video, I'll be giving you 5 shocking reasons why Mazi Nnamdi Kanu may be released on the 26th of September, which is Friday. And number 3 reason will blow your mind away. It will definitely shock you. So whatever you are doing, please leave it and focus on this video, or you go and finish it up, and when you're done, you come back and watch this video because you do not want to skip a bit. Listen to this. The sudden abridgment of Nnamdi Kanu's no-case submission ruling from October 10th, 2025 to September 26th, 2025 could signal judicial intent to swiftly address evidentiary or procedural flaws in the prosecution's case, potentially leading to a discharge and acquittal. In Nigerian jurisprudence, expedited rulings, often triggered by motions highlighting prosecutorial weaknesses, have historically favored defendants when the state's evidence fails to meet the burden of proof beyond reasonable doubt. Now, having said this, listen to these 5 strong reasons why Mazi Nnamdi Kanu may just be released on the 26th of September. Listen very carefully. Number 3 will blow your mind. Now, the first reason is this: insufficient prosecution evidence, which is failing to establish a prima facie case. Nigerian courts can discharge a defendant at the no-case stage if the prosecution's evidence is manifestly unreliable or inadequate. The abrupt scheduling may indicate the judge's recognition of such gaps in Kanu's terrorism trial, mirroring the 2010 armed robbery case between the Lagos State government versus Arowolo, as documented in Lagos State Ministry of Justice records. In that matter, the High Court conviction was expedited on appeal and overturned by the Court of Appeal due to the prosecution's failure to prove burden of proof and proper identification, leading to the defendant's acquittal without full retrial. Now, number 2, unlawful extradition and arrest rendering proceedings a nullity. Kanu's 2017 rendition from Kenya is illegal, so the courts could void the trial entirely, with the sudden ruling allowing prompt enforcement of his human rights. This echoes the 2024-25 Kenyan High Court decision in Nnamdi Kanu versus Federal Republic of Nigeria, where the court ruled Kanu's arrest unlawful and awarded a 119.6 million naira damages and ordered his release, prompting expedited Nigerian proceedings that could align with international committee. Nigerian courts have similarly abridged cases for extradition flaws, as in FRN versus Enwenede Solomon 2019 Supreme Court, where jurisdictional irregularities led to a swift dismissal favoring the defendants. Now, number 3. Listen very carefully to number 3. Listen very carefully. Health and detention conditions necessitating immediate release. Kanu's recent motion for transfer to the National Hospital due to a life-threatening heart condition, combined with the rescheduling, may prompt a humanitarian ruling in his favor. Courts have expedited such matters to avoid constitutional violations under Section 35 of the 1999 Constitution. A parallel is the 2021 interlocutory application in Alhaji Mujahid Dokubo Asari versus Federal Republic of Nigeria, where the Federal High Court abridged hearings on health grounds, discharging the defendant from prolonged DSS custody after evidence of inadequate medical care emerged, prioritizing rights over trial continuation. Did you just hear that? Did you just hear that? So you heard that number 3. You heard it clearly. Asari Dokubo was sick in the DSS dungeon, and the court ruled that because he was not treated properly well, he was discharged. This happened in Nigeria. Asari Dokubo, a well-known terrorist, a well-known criminal. Asari Dokubo, a well-known terrorist, was released by the Nigerian court because he was sick. Just exactly what is happening to Nnamdi Kanu now. This is a carbon copy situation. That's why I said number 3 will surprise you, will shock you. And look at how he was treated. He was sent home. The court ruled in his favor that you cannot try him because he's sick and he has been kept there without medical treatment. That alone, on medical grounds and unfairness, led to his release that moment. And that is exactly what we call for Mazi Nnamdi Kanu now, for his immediate release. And we believe that the judge will also using this basis, will also discharge Nnamdi Kanu on that day, on these same health grounds. If not for any other grounds, he should be discharged immediately. Lawyers of Nnamdi Kanu, please be very observant on this particular point and make sure that you use it as a leverage anytime you need it on that day. Let's go on. Number 4, prosecutorial misconduct or abuse of process warranting discharge. Allegations of duress in witness statements or fabricated evidence could lead to a no-case ruling, with the expedited date suggesting the court's aim to curb abuse. This aligns with Federal Republic of Nigeria versus Nwobodo 1980s political trial, where the High Court, upon a sudden motion, discharged the defendant mid-trial due to prosecutorial overreach and unreliable evidence, as affirmed on appeal, expediting justice to prevent vexatious proceedings under the Criminal Procedure Act. And number 5, judicial efficiency in high-profile cases to uphold fair trial rights. In politically sensitive trials, courts often abridge timelines to affirm constitutional speedy trial guarantees. Section 36, discharging defendants when evidence doesn't sustain charges. The 2015 Goodluck Jonathan era case, Dasuki versus FRN, exemplifies this. Arms procurement charges were expedited on a no-case motion, resulting in partial acquittal and bail after the court found insufficient links to terrorism, emphasizing expeditious rulings to protect defendants from indefinite detention. These are 5 reasons why Mazi Nnamdi Kanu may be released on 26th. And of course, you heard that number 3 clearly in the case concerning Asari Dokubo versus Nigerian government, where the court ruled that his health is more important than, a case. And like I always say in my video here all the time, that it is the person before the case, always. You say habeas corpus, people should come presently and defend themselves. And a dead man cannot come to court, as well as a sick man cannot come to court. So health is priority before, prosecution. And Asari Dokubo had a case with federal government, and the federal government ruled to his favor, granting him request to go because he was unfairly treated in the DSS dungeon and he had an issue with them. And this also will also happen to Nnamdi Kanu, hopefully, because his health is already bad. And October 10th may not even arise if they don't treat him, because a sick man cannot appear in court, and I've always said it on my channel. The number 5 point also made it very clear that you cannot base a trial on illegality. You can't keep prolonging a case for a long time and witch hunting a man, knowing very well that as you keep on prolonging that case, he will spend longer time in the cell. So in criminal cases, it's always advised, and it's also in the law, that you must treat these cases, expedite justice quickly, so that people don't spend prolonged time doing nothing in the cell, which can turn to a judicial witch hunt. That is exactly number 5. And that's the reason why the court may have just brought up this case forward, because we've always been fighting here. For those of you who have been watching this channel very well, you know that I've always been saying that October 10th is too far. It's too far. You can't push a case that far. And I've always been fighting for it, that this is witch hunt, because throwing a case that far is judicial witch hunt on its own. And this 26th of September is quite far, but at least the closer the better. You can't keep doing things like this all the time. So, but we hope this leads to an acquittal and a discharge of Nnamdi Kanu, because I know very clear that Mazi Nnamdi Kanu may not be at his best when it comes to his health. And on that 10th of October, it's too far. Things can change overnight, which we don't want, because nobody is praying for that. And that is why we are here, to make sure that we fight for the justice of Mazi Nnamdi Kanu. And hopefully, just like we have said in these 5 strong points, we hope, we pray, we have faith that Mazi Nnamdi Kanu will be released on Friday, the 26th of September. We hope and we believe that Mazi Nnamdi Kanu will be released on the 26th of September, which is Friday. And we'll be here every day till then. Keep pressing, keep fighting, as we've always done. Keep faith and keep strong. Don't lose hope, because we are here to stay. And we're not going anywhere, because we are here to fight the injustice. And we are here to stand in defense of the Igbo race, no matter who it is and no matter what ideology he or she believes in. I have been your host, Chi Ne Du. Thank you for watching my video. So I'll see you next one. Peace.